In this video, I'm going to be talking about the top 3 Florida estate planning mistakes I see being made. There are certainly more than this, but these are the top 3 that I happen to see over and over and over again, and I'd like you to not be one of them. So, number 1 is with regard to your home or any real estate that you own. The mistake I see people making is adding their children to the deed. And I get the instinct. The instinct is you want to avoid probate, and adding children to the deed will in fact allow them to avoid having to go through the probate process. However, it comes at a steep cost because we have other ways of making sure that the home or the real estate gets to the next generation without probate that don't involve the same cost. And the concept is this. When you put your children on the deed before you pass away, they lose what's called the step-up in basis. This is particularly horrid when you have a property that is old, that has been lived in for a long time. So for example, I'm based in South Florida and I work with a lot of people who might be in their 70s or 80s and they have real estate that they purchased 30 years ago, right? So they might have bought a property for, let's call it $100,000, and now that property is worth $600,000 or $700,000, okay? And when you lose the step up in basis, when your children go to sell the property that they were able to successfully avoid probate, so it's not completely without merit, but when they go to sell a property that's worth $700,000 after you've passed away, when you purchase it for $100,000, they're paying capital gains taxes on $600,000, the full difference between 100 and 700 in this hypothetical example. Whereas if they inherit your property after you pass away, whether it's through the will, which we don't recommend because a will still involves probate, or they inherit the property using what's called a ladybird deed or a revocable living trust, which do avoid probate. But when they only own it through one of these mechanisms, now they get the step up in basis. So now instead of paying taxes on what you purchased the house for, they're paying taxes on the difference between the value of the property at your death and when they sold it. So if they sell it shortly after you pass away or within a year or so, the taxes are negligible, right? So that is the first big issue that I see, the first big misunderstanding and mistake I see people making with their estate plan is adding children to the deed. Don't do it. The second is with regard to the last will and testament. A lot of people, and I've talked about this in videos before, they believe that by having a will that they've done their job and now their assets will avoid going through probate because the will says who's supposed to get your assets after you pass away. And while the will does say that, the will is a very important legal document, but a will is not effective until after you've passed away and somebody presents it to a judge. Relying on a will, by definition, means that your loved ones are going to probate court to read the will, to figure out where it's supposed to go, put creditors on notice, and again, all of that can be avoided by using a revocable living trust. So a will, this mistake that I want everyone to be aware of, is a will by itself does not avoid probate in the state of Florida, okay? The third biggest mistake I see people made is relying on outdated or free durable powers of attorney. There is no such thing as a general power of attorney that just with a statement like, I give my agent or attorney, in fact, the ability to do everything they need to do for me as if they were me, that doesn't exist anymore. Meaning in Florida, the power of attorney has to be very, very specific and it has to be signed the right way. It has to be initialed the right way, as with all these documents. But powers of attorney are specifically, can be pernicious because it gives a lot of people a false sense of security. I've given my loved one a durable power of attorney that's very general and broad, and so I feel like I'm in good hands. And if it wasn't done by an experienced estate planning or elder law attorney, there is a risk that the power of attorney will be good for certain things. Like usually it's fine for things like banking, maybe dealing with real estate, but it typically won't be fine for things like when someone comes to me for Medicaid planning and we have to create these very special types of trusts and these really intricate Medicaid planning strategies that we can't do because their power of attorney isn't specific enough. It's almost too broad. Another way people commonly get themselves in trouble is by having a poorly drafted durable power of attorney. So we call ours our enhanced durable power of attorney or a Medicaid compliant power of attorney, because we're thinking about these things that maybe other non-estate planning or non-elder law attorneys are just not thinking about, and certainly those free forms you get on the internet are not thinking about it either. So I hope that helps. Those are the 3 most common mistakes or misunderstandings I see people making with regard to their estate planning, and I don't want you to make the same mistake. If you found this video helpful, I hope you'll share it. I hope you'll give it a thumbs up, subscribe to our channel. If you are anywhere in the state of Florida and want to talk about probate, estate planning, or Medicaid planning, please set up a consultation. We're here to help. Thanks for watching.